Hi, I'm Eric Cherry, family law attorney at Weiss Law. Navigating a family case can be very daunting, especially if your relationship is on the rocks and you have children and you're worried what might happen in the upcoming custody case or divorce. You may have talked to some of your friends about what their orders look like if they've already separated and have children, and many of them have probably brought up shared parenting to you. I know for my part, when a new client comes into our office and wants to talk about shared parenting, they usually assume that means that each parent will have the child in their possession 50% of the time. That is not necessarily true. What shared parenting contemplates is shared decision-making regarding the child. It has nothing to do with the schedule directly. You can have a shared parenting plan where one parent only has alternating weekends, maybe a midweek day. You can have a sole custody plan where there's only one decision maker, but both parents have 50% parenting time. Now, what is included in shared parenting as far as decision making goes? The big ones are medical decisions and educational decisions. If you're in a shared parenting plan, both you and your spouse or partner or the other parent get to make those decisions. If the two of you disagree about a decision, there's usually some sort of tiebreaker provision in the plan. If we're under a sole custody plan, the person who has sole custody is the only decision maker. So even if you're jumping up and down and are completely right about the child's medical situation, if you're not the custodial parent, your opinion doesn't matter. And that's why shared parenting tends to be the preferred course of action for the courts unless there's a good reason not to do that. Now, shared parenting does come with some pitfalls, though, that everybody should be aware of. Shared parenting contemplates that two parents are going to spend their time and their efforts jointly with the child. So both of them are going to be going to the schools. Both of them are going to be talking to the teachers. Both of them are going to be talking to the doctors and other medical providers. They may not do it all the time together, but each of them are going to be intimately involved. Neither parent is the concierge for the other, meaning that if you are in a shared parenting plan, that doesn't mean that your spouse, if they go to the medical appointment, has to give you all the documents from it. You are expected to take some personal effort and get involved on your own and get those records. And if you have an issue, call the doctor yourself. Same is true for the school. Same is true for religious decisions. Same is true for social decisions. If your daughter is seeing a boy down the street that you don't like and you're a decision maker, you get to tell that boy or your daughter to stay away from that boy. Another consideration, because shared parenting involves that intimate joint involvement, it's very difficult for one parent to move, particularly the parent who is the residential parent for school purposes in the plan. Every plan in a shared parenting plan will designate one or the other to be the residential parent for school purposes. That doesn't mean you have more rights. A lot of people think that. That is not true. What that means is that the state, in this case, the state of Ohio, knows where to send some funding for your child if they're going to public school in your district. But because it also means that both parents are intimately involved, as we've said, if you want to move because of your new job in Texas, you have to file a motion well ahead of the intended move. And your spouse, ex-spouse is likely going to want to come back to court and figure out what the parenting plan is going to be. And maybe if your child is older and has gotten involved with a lot of friends, a lot of extracurricular activities, gotten really tied into the school, you might be giving your ex-spouse residential parent for school purposes and moving on your own. So you should know that before you go into a parenting plan that has shared parenting. If you intend to move, that should be something you talk about with your attorney early on. With that said, again, shared parenting is the preferred method from courts these days because they want both parents to continue to have complete legal rights to their children, absent a good reason not to. If you think that reason exists, you should be talking to your attorney about it early on so that we can prepare to argue that it should be a sole custody plan in your favor. Either way, shared parenting or any parenting order from a court requires a certain amount of advanced planning in order to go into court well prepared for the intended outcome. So you should be discussing that with me or your family law attorney of choice to determine a plan before a divorce is filed or before a custody case occurs. If you have any questions, feel free to call me at Weiss Law. My name is Eric Cherry. Thanks.